Discussion on agency. Okay, chapter 1, the nature, form, and kinds of agency. We are done with the definition of an agency. So, yan, mababasa nyo naman doon sa Article 1868 yung definition ng agency. Okay, you go with the characteristic. An agency is a principal, nominate, bilateral, preparatory, commutative, and generally onerous contract. Generally, it is also a representative relationship, okay, not a status, since agency is not inherent or permanent. So, ang agency daw is representative relationship. Hindi po siya isang status, okay, because it is not permanent and it is not inherent, okay? It is also fiduciary relationship since it is based on trust and confidence. Remember, doon sa unang discussion natin, pag wala na pong trust and confidence yung principal natin, it can now end the principal-agent relationship. Remember that there are two parties in the contract of agency. This is the principal and the other one is the agent. Okay? The principal is one whom the agent represents and from whom he derives authority. The principal is the one primarily concerned in the contract, while an agent is the one who acts or stands for another. Usually, he is given full or partial discretion, but sometimes he acts under a specific command. Remember, okay, an agent therefore acts in another's name. So, if he acts under another's name, that is, if he pretends to be someone else, he is not agent, for here he certainly acts in his own name. Also, an agent may have his own agent, who is therefore referred to as sub-agent. So, ang agent natin, okay, pwede siyang magkaroon ng sariling agent niya, and you call that sub-agent. So, with regards to the capacity of the principal, okay, a principal in general, okay, if he is capacitated to act for himself, he can act through an agent. Therefore, a principal must be capacitated to give consent. A principal may be a natural or a juridical person. Na-discuss na natin yan before. A natural person is like the human beings, while a juridical person or those that are, example, private corporation, a partnership, okay? Remember that these juridical persons can only act through their agents. Okay, with regards to the capacity of an agent, okay, his capacity is in general the same as in the law of the contracts. That is, he must be able to bind himself but only insofar as his obligation to his principal are concerned. So, insofar as third person are concerned, okay, it is enough that his principal be the one capacitated. For generally, an agent assumes no personal liability. So, usually, okay, the contract with a stranger is valid. Okay, kahit na yung agent is a minor. Okay, remember, a minor is not capacitated to give consent kasi nga po minor pa siya. So, in the eyes of the law, okay, a minor cannot give an intelligent consent. So the contract with a stranger is valid even if the agent is a minor, so long as his principal is capacitated. Okay? However, as between the principal and the agent, okay, the agent who is a minor can set up his defense, okay, that he is incapacitated. Okay, provided, however, that he is also not in estoppel or he is not estopped. Okay, So, let us give an example. So, Pedro, okay, Pedro appoints Amor, okay, a minor, as his agent to sell certain goods. So, si Pedro is 60 years old, si Amor is a minor. So, si Pedro ang principal natin, si Amor ang ating minor agent, okay, as his agent to sell certain goods. So, Amor sells the goods to a buyer. Let's say the buyer is Brian, okay? So, afterwards, okay, Pedro seeks to disaffirm the sale and brings an action to recover the sale on the to recover the goods on the ground that Amor's act was void as an infant and cannot be an agent. So, judgment for whom and why? Okay, kanino ka in favor? Okay, the judgment should be, okay, for the buyer Brian and against the principal Pedro. So, why? Okay, the agent Amor, who is a minor, is deemed to be an extension of the personality of the principal. Diba kakasabi ko lang kanina that the contract with a stranger is still valid even if the agent is a minor, so long as the principal is capacitated. Okay? Hence, Pedro cannot avoid the contract on the ground of agent's incapacity. So, we will rule in favor of Brian, who is the third person or the stranger to the contract of agency. Okay? So, we will consider the sale as valid. For your assignment, kindly read the difference between an agency and a guardianship. Okay? An agency from judicial administration. Okay? An agency from list of property. Agency from list of services. Agency from a contract with an independent contractor. Agency from negotiorium gesto, agency from trust, agency to sell from sale, agency to buy from sale. Yan, assignment nyo po yan. So, we distinguish an agent and a broker. Okay? An agent receives a commission upon the successful conclusion of a sale. On the other hand, a broker earns his pay merely by bringing the buyer and the seller together, even if no sale is eventually made. A broker is one who is engaged for others on a commission, negotiating contracts relative to property with the custody of which he has no concern. A broker is one whose occupation is to bring the parties together in matters of trade, commerce, or navigation. Sa Article 1869, okay, we will now talk about the kinds of agency. Okay? First, according to manner of constitution, an agency can be through express or by implied. Okay? When we say implied or implication, it can be from the acts of the principal, from principal's silence, principal's lack of action, or principal's failure to repudiate the agency. Okay? In these cases of implied agency, the principal knows, okay, so may knowledge po yung principal natin, that another person is acting on his behalf without authority. Example, in the case of De La Peña versus Hidalgo, okay? The facts of the case. The properties of De La Peña were being administered by his agent Federico Hidalgo, who, for reasons of health, informed De La Peña that he, Federico, was turning over the administration to Antonio Hidalgo. Federico also informed his principal that he had conferred a general power of attorney on Antonio and requested that in case this would not be sufficient, De La Peña could send to Antonio a new power of attorney. De la Peña did not repudiate the designation of Antonio, nor did he appoint a new agent. Moreover, he remained silent for 9 years, okay, all the while allowing Antonio to administer the property. The question is, was Antonio the agent of De la Peña? The answer there, okay, is yes. From the facts given, this is a clear case of implied agency. In permitting Antonio to administer, De la Peña created in Antonio's favor an implied agency. Okay. According to form naman tayo. According to form. It can be oral or written. Okay? As long as, okay, sabi sa batas natin, oral, kung ang agencies na buo, in oral form only or galing sa bibig ng tao, that is already sufficient. Okay, in written form naman, okay, an example of an instance when the law requires a specific form for the agency is in Article 1874, which states that when a sale of land or any interest therein is through an agent, the authority of the latter shall be in writing, otherwise the sale shall be void. So, kung nagbenta ng lupa ang agent, it must be in writing. Otherwise, yung status ng sale shall be declared to be void. Article 1870 and 1871 are self-explanatory. Let's give an example naman sa Article 1872. Okay? Anna had a horse deposited with Ben. One day, Anna asked a friend, Chris, if Chris would take the horse from Ben and sell it for her, Anna. If Anna would write him, Chris, a letter to that effect, okay? Chris answered yes. Subsequently, Anna wrote Chris to get the horse from Ben and to sell it. Chris did not answer, but proceeded to get the horse and was subsequently able to sell it. Question: did Chris act as Anna's agent? The answer there is yes, because in the given case, okay, for the acceptance of the agency could clearly be inferred from his own acts. Remember that Article 1872 provides for the rules in case the parties are absent, okay? Next article, okay? We will talk about agency by estoppel. Okay? An agency by estoppel example. If A leads B to believe that C is his agent, okay, is his agent, when as a matter of fact is not true, and B acts on such misrepresentation, A cannot disclaim liability for he has created an agency by estoppel. Okay, so the Supreme Court in the case of Mack et al. Versus Camps, okay, the Supreme Court said that one who clothes another with apparent authority as his agent and holds him out to the public as such cannot be permitted to deny the authority of such person to act as his agent and to the prejudice of innocent third parties dealing with such person in good faith and in the honest belief that he is what he appears to be. So, what is the difference between an agency by estoppel from implied agency? Okay? As between the principal and agent po. Okay? In an implied agency, the agent is a true agent with rights and duties of an agent. Sa isang agency by estoppel, of course, the agent is not a true agent. Hence, he has no rights or whatever. Okay? As to third persons naman, if the estoppel is caused by the principal, ang dahilan ng estoppel is yung principal, he is liable. Siyempre, siya nga ang dahilan. But only if the third person acted on the misrepresentation. Kung napaniwala daw po yung third person. Okay? In an implied agency, the principal is always liable. Siyempre, an agency can be established through implication. Okay? If the estoppel naman is caused by the agent, it is only the agent who is liable. Bakit? Siyempre, hindi naman po with the knowledge si principal. Okay? Okay, never the alleged principal. In an implied agency, of course, the agent is never personally liable. Remember po, in our old civil code, okay, the agency was presumed to be gratuitous. Gratuitous in nature meaning wala pong bayad, okay, or free. Ngayon, sa new civil code natin, ang agency is presumed to be for compensation. Okay, so what is the form of compensation? Okay, compensation may be in the form of gratuitous use by the agent of the principal's real estate. In the absence of stipulation, the agent is entitled to compensation only after he has substantially completed his obligation as agent. Okay? The compensation may be a contingent or dependent upon the realization of profit for the principal. This is so in case there is stipulation to that effect. Okay? In your Article 1878, in-state po doon kung saan or what instances kailangan ng mga special power of attorney. There are 15 instances, so kindly read them all. In general term, okay, according to Justice Reyes, the acts referred to in Article 1878 can be reduced into 3. Number 1, acts of strict dominion or ownership, okay? One that is gratuitous contract, and lastly, contracts where personal trust or confidence is of essence of the agreement. So, what is the reason for the rule? Okay? In the cases enumerated in this article, okay, we have in general acts of strict ownership or dominion and not mere acts of administration. Hence, the necessity of special power of attorney except in the cases expressly so mentioned. Hindi daw basta-bastang management of properties lang kasi yung andoon sa Article 1878, but also there is a general acts of strict ownership or dominion. Kaya po kailangan ng special power of attorney. Okay, we proceed with Article 1879. Your Article 1879 talks about the special power to sell excludes the power to mortgage, and special power to mortgage does not include the power to sell. Sa power to sell, it includes or carries with it the power to find a purchaser or sell directly, okay, to deliver the property, to make usual representation and warranty, to execute necessary documents, to power to sell only for cash, power to fix the terms of the sale, power to receive the price unless he was authorized only to solicit orders. Okay? Whereas to power to mortgage, the power to mortgage does not include the power to sell. It also does not include to execute a second mortgage. We go to Article 1881. Okay? What are the fundamental principles of agency? Okay? Accordingly, there are two very important principles of true agency. Number 1, the agency must act within the scope of his authority. Okay? May limit yung authority niya at dapat yun lang yung mga dapat niyang gawin. Number 2, the agent must act in behalf of his principal. Okay? It is therefore conceivable that an agent may act under two conditions given, or under only one of them or under neither. Thus, four instances may arise. Number 1, the agent acts with authority and in behalf of the principal. He can also act with the authority but in behalf of himself. The agent acts without authority but in behalf of the principal. And lastly, the agent acts without authority and his own act. What is the effect if the agent acts with authority? Okay? In principal's behalf, of course, all the actions are valid. The principal is bound and the agent is not personally liable unless he bounds himself. In agent's behalf, of course, apply Article 1883. Generally, not binding on principal. Okay, syempre, on behalf of agent la pa yun eh. Agent and stranger are the only parties except regarding to things belonging to the principal. Na-discuss na natin yan before. Okay? How about if the agent acts without authority? Okay? In principal's behalf, it is unauthorized and unenforceable. Okay? Can you ratify it? Okay? On such case, okay, there are cases in which case it can be validated from the very beginning. Okay, na-discuss na rin natin yan before. Okay? If it is in agent's behalf, unauthorized act, okay, or one that is unauthorized, of course, it is valid because whether or not the subject matter belongs to the principal, provided that at the time delivery is to be made, the agent can transfer legally the ownership of the thing. Otherwise, he will be liable for the breach of warranty against eviction. With authority and in principal's behalf. Okay? Pedro authorized Ana to sell his car. Ana then sold the car in Pedro's name. Of course, the transaction is valid and Ana assumes no liability. With regards to with authority but in agent's behalf, okay? Pedro authorized Ana to sell his car. Ana then sold the car in his or in her own name. Ang naka-appear sa transaction is Ana without disclosing who the principal was. Okay? What happens? Ordinarily, the agent can only have recourse against the buyer, and the buyer can have recourse only against the agent. However, in this case, okay, since the car belonged to the principal, Pedro can have recourse against the buyer, and the buyer can have recourse against Pedro. Okay, we go with the without authority naman. Without authority but in principal's behalf. Without Pedro's authority, Ana sold Pedro's car to a buyer in Pedro's behalf. The transaction in so far as Pedro is concerned is unauthorized. Diba na-discuss natin kanina yan. And hence, it is not enforceable. Okay? Pedro therefore is not bound unless he ratifies the transaction. Okay? Without the necessary ratification, the buyer can have a claim only against the alleged agent, Ana. Okay? So, the moment na meron ng ratification ni Pedro, Ana steps out of the picture since she would no longer be personally liable. And now it is the principal, who is Pedro, who will have to deal with the buyer. Paano naman kung without authority and in behalf of agent mismo? Okay, Ana, without authority from Pedro and representing himself to be the owner of Pedro's car, sold it to a buyer. Here, Ana acted without authority. Moreover, she acted in her own behalf. It is clear that the transaction is valid provided that at the time of delivery is to be made, the agent can transfer legally the ownership of the thing. Otherwise, she will be held liable for breach of warranty against eviction. Okay? Because, bakit po? One of the duty is to warrant that the thing is free from any lien or attachment. Okay? It is also clear that only Ana is liable to an innocent purchaser. Hence, okay, Article 1883 does not apply because Article 1883 presupposes authority.